Morning, Judge. Chad Mason here on behalf of Wayman Stewart, who is on page 8 of the morning docket.
Okay. All right, Wayman Stewart?
He's right there.
All right, Mr. Stewart, you are charged with 7 counts. The first being DUI causing death, second is DUI causing death, and then DUI serious bodily injury for counts 3 and 4. Counts 5, 6, and 7 are DUI with property damage. Would you find probable cause?
Yes, it is. I'm sorry, yes, you're right.
We're on page 8.
It is 8.
Okay.
We don't have a lot of.
So, Judge, what we're asking for today is for a reasonable bond on the counts, I guess counts 1 through 4. Obviously, if there later were any conviction, I believe counts 2 and 3 and 4 would go, or however this works out. But either way, we're asking for a reasonable bond. Mr. Stewart contacted us over a month ago, and he wanted us to be on board so that he could surrender himself on this case. So I've been in touch with Mr. Weiner from the state for the past 4 or 5 days. We had arranged for yesterday for him to surrender himself, so we walked him over to the main jail. He's been completely cooperative with that. But, you know, obviously there's a presumption of innocence in this case. I know the state's moving for pretrial detention, although they're going back to a DUI from 1995 as the basis for that, which is over 22 years ago. But I do believe that he should be entitled to a reasonable bond. Certainly the court could impose pretrial release with certain safeguards if the state's concern is that he potentially could be driving again or something along those lines. There's things the court could do to ensure that he's not doing that under the influence, that we could do an interlock device on his vehicle, pretrial release with a GPS is an option. So again, I mean, it's not a capital case. We're certainly asking for a reasonable bond.
Detention pursuant to Florida Statute 907.0414C4 and pursuant to Florida Rule of Criminal Procedure 3.1321A. If the court finds that there is probable cause to believe the defendant committed a crime and that the motion filed by the state is facially sufficient, the court may detain the defendant pretrial pending a final hearing. We're asking the court to grant the state's motion pretrial detention. At this point, if the court grants it, the case would be set before Judge McCarthy, the division judge. The rule requires within 5 days where a full evidentiary hearing would be conducted, and Judge McCarthy would then determine whether to formally hold the defendant no bond or to set a bond. So we're asking the court to initially hold the defendant no bond pending a final hearing before Judge McCarthy within 5 days.
Well, I do find probable cause, and the motion for pretrial detention is facially sufficient. You know, the concern here is not only that he has a prior, albeit it is fairly remote in time, 22 years ago. And the allegations in this case is that he had three times the legal limit of blood alcohol limit. And I will hold him on pretrial detention pending Judge McCarthy's determination.
Able to get a date in front of Judge McCarthy today from the clerk?
I will email. I spoke to Jay yesterday. She said as long as we call her, we can get a date, maybe even tomorrow.
Okay,
So
that's
I'll
perfect.
call her
As soon as possible.
Yes.
I am.
From 1 to 7 will be now no bond?
Or actually,
That just counts
1 through 4.
for- hearing everything.
Yep. Mr. Stewart, can you hear? Did you hear what we were doing?
Yes.
Okay. You were going to get a hearing in front of Judge McCarthy within the next 5 days. Hopefully, we'll get that in for you tomorrow. But the state's going to have an opportunity to have a full hearing as well as hear any testimony on your behalf. So you'll be held until that hearing. Okay?
Okay.
Good luck to you, sir.
Thank you, Judge.
All right, take care. Tina Kruger.
All right.
Ms. Kruger, you are charged with a capias on a misdemeanor. I do find probable cause. Your bond is $100. Good luck to you, ma'am.
Your Honor, if we could call one case out of turn, please, Anthony Millian on page 7. I believe he's at main jail.
Mr. Millian, come on up, please. Anthony Millian. He's approaching, Judge.
No problem. I'm just pulling his. All right. State.
Yes, Your Honor, we're just asking that this case be sent and heard before Judge Cohen this morning in domestic violence court. I know the PC affidavit lists the two parties as roommates, but I spoke with the alleged victim this morning. There is other information that I think would make this eligible for domestic violence court. And additionally, Your Honor, Mr. Millian has a pending violation domestic violence injunction case against the same alleged victim before Judge McHugh.
I thought in reading this was potentially a domestic violence, so I will grant that motion to transfer over to the domestic violence.
No, I was just, Patrice was telling me.
Oh, okay, all right.
He's on pretrial. I was gonna ask the court to revoke his pretrial supervision based on the court's finding probable cause.
I guess it'll have to be up to Judge Cohen.
Yeah, I'm gonna transfer this to Judge Cohen.
Okay, thanks.
Okay, so,
All right,
we'll get this over to Judge Cohen.
thank you, Judge. And that'll, yeah. And the deputies, I'm sure, will take care of that also.
Okay. Shantaria Tillman?
Ms. Tillman's here present, Judge at Maine. Ms. Tillman, come on up, please. Judge, in speaking with Ms. Tillman, she didn't know she had court. She didn't know that she missed a court date. But in speaking to her, Judge, I did advise her as far as what we could potentially do today. And she wants to inquire with Your Honor if you would consider resolving her case today.
State of Trooper?
I'm just checking that right now.
Is it possible to go back to Tina
Does she
Kruger?
have
I
anything?
meant to tell you she was in custody at the time of
It's
the
okay.
visitation.
Oh, really?
Okay.
If that changes anything, if it doesn't.
No.
Oh, okay.
I'm sorry,
Yeah, I don't, Your Honor, I don't see any criminal history. I'm just checking the probable cause affidavit to make sure there's no issues with that.
Oh, Your Honor. Could you unlock the door, please?
Okay, and Your Honor, the allegation is that Ms. Tillman stole just under $176 worth of merchandise from Walmart on North University Drive in Fort Lauderdale. It appears the property was recovered.
Okay. And she has no priors.
No.
Yeah,
Considering she has no prior, would you consider a withhold and take judicial notice of the time she served?
yes, I will. Yes, I will.
Thank you, Judge.
All right,
Judge is gonna answer your question.
Ms. Tillman, I
Yes.
indicated that if you wanted to resolve this case today, I would withhold adjudication. It does not appear that you have any prior record, at least according to the state, so I would withhold adjudication, meaning that would not be a conviction on your record, and I would take judicial notice of the credit for the time and give you credit for the time you served. So no court cause. Is that something that you want to do?
Okay.
Okay.
Yes.
Can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name, please?
I'm sorry?
Can you state your full name, please?
Shantaria Venetria Tillman.
Okay, Ms. Tillman, you can put your hand down. All right, Ms. Tillman, I indicated to you that I would offer you a withheld adjudication, basically credit for the time you've already served on this case. Is that what you want to do?
Yes.
Okay, and how do you wish to plead, guilty or no contest?
No contest.
All right, I'll accept your no contest plea. I'll withhold adjudication, taking judicial notice of the credit for time served. Good luck to you, ma'am. Wait for it.
Okay, thank you.
Shalimar Wright?
North Park.
Ms. Wright, you were charged with one misdemeanor capias on a traffic criminal offense. I do find probable cause. Your bond is $250. Is this the only thing holding her?
Yes, Your Honor.
All right, ma'am, if you want to resolve this case, do we have, does Ms. Wright have any priors?
2016 possession of, I'm sorry, that was dropped. 2014 petty theft and resisting without violence. Battery in 2008.
Okay. Ms. Wright, if you want to resolve this case today, I would adjudicate you guilty, give you credit for time served, if that's something that you want to do.
Yes.
Okay. You've already raised your right hand, so do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you please state your name, please?
Shalma Diana Wright.
Okay, Ms. Wright, you can put your hand down. Ms. Wright, I offered you an adjudication with the credit for time served. Is that something you want to do?
Yes, sir.
All right, how do you wish to plead, guilty or no contest?
Guilty.
All right, I'll accept your guilty plea. I'll adjudicate you guilty, give you credit for time served. Good luck to you, ma'am.
Okay, thank you.
Melanie Minor?
North Road, Your Honor.
Good morning.
Morning, ma'am. You are charged with one misdemeanor capias. I do find probable cause. Your bond is $250.
Pardon?
Your
I
bond-
went to court that day, and they said I wasn't on the docket. So I thought maybe it was dropped.
Yeah,
They said this. They
appar-
said you're not on the docket.
Yeah, apparently it wasn't dropped, but there was a capias out there for you. State, what?
Yes, Your Honor.
What's your record?
Got it.
She had a prostitution.
That's the same one. She had, anything before the 04? Her last prior, no prior prostitutions from what I can see. Her last prior was, uttering a forged instrument and theft in 04.
Okay, ma'am, if you want to resolve your case today, and it's completely up to you, I would withhold adjudication and give you credit for time you've already served.
Yes, sir.
All right, ma'am, can you raise your right hand?
Yes, sir.
You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name, please?
Melanie Marion Minor.
All right, Ms. Minor, I indicated to you that if you want to resolve your case today, I would withhold adjudication, give you credit for time served. Is that something you want to do?
Yes, sir.
All right, how do you wish to plead, guilty or no contest?
No contest.
Okay, I'll accept your no contest plea, sentence you to a withheld adjudication with credit for time served, waiving court costs and fines. Good luck to you, ma'am.
Thank you, sir.
Shipper Stevens?
Good morning.
North
Road, Your Honor.
Good morning, ma'am.
Good morning, Judge. She's charged with a City of Fort Lauderdale municipal ordinance violation of trespass.
Yes.
I've represented Miss Stevens, or Miss Morgan, in the past.
Okay.
Haven't had an opportunity to speak with her though, Judge. Could I get a moment just to give her a call over there? No problem?
Absolutely, I'll put it on recall.
Okay, thank you.
Your timing is excellent this morning, by the way. That's the first case.
Sit right there.
Talise Cassidy?
North Road, Your Honor.
Ms. Cassidy, you are charged with 2 violations of probation on felony charges. I do find probable cause. You are being held no bond on those cases. You do have a VOP status conference set on the 20th of this month at 8:30 in the morning in front of your division judge.
The 20th of this month?
Yes, ma'am. That would be next Monday, I believe.
Okay.
All right? Good luck to you, ma'am.
And, Your Honor, I apologize. If we could call one other case at a turn, there's, I have a detective present in court.
Hold on for 1 second. Yes, ma'am?
I have an attorney. Is he here or no?
There's nobody here right now. I don't know who your attorney was, but he's not here.
Gary Ostro.
Well, I mean, you can call Mr. Ostro, but there's no requirement that he be here for a first appearance.
Okay.
Okay?
All right. Thank you.
I believe he's on page, what's 12, Frankie Vargas. 12, right? Page 12, Frankie Vargas. Page 12, Frankie Vargas.
Yes?
Mr. Vargas here, Judge.
Okay. All right. Mr. Vargas, you are charged with 2 counts. One is an out-of-state hold, I believe it's from Pennsylvania, and the other is grand theft auto. I do find probable cause on both of them.
And Your Honor, and I do realize Mr. Vargas has a no bond out-of-state hold. What we just wanted to bring to the court's attention, just so the court is aware, and whatever bond you determine to be appropriate, Mr. Vargas's criminal history. Out of St. Lucie County, 2011, he was convicted of 2 counts of credit card fraud, fraudulently obtaining property, burglary of a structure, and 2010 out of Palm Beach County, credit card fraud. On the St. Lucie County cases, he was sentenced in 2014 to 4 years state prison. He was just released from state prison May 14th of this year. He's already been arrested. He was arrested on October 6th of this month and is out on bond on a possession of cocaine. Now, I would advise the court 2 counts of possession of cocaine. A filing decision has not been made, so I will advise the court of that. And as you can obviously tell, he has an out-of-state hold for assault on a law enforcement officer out of the state of Pennsylvania.
There was a bond on those 2 possessions of cocaine cases?
On one count, he had a $1,000 bond. On the second count of possession of cocaine, he was ROR.
Okay. Well, the finding of probable cause on this case, go ahead.
No, I'm sorry.
The finding of probable cause in this case indicates that he has violated the terms and conditions of his bond on those previous cases for possession of cocaine, so I am going to revoke his bond on those previous possessions of cocaine case. You have this case.
Judge, what's the case number on that case that he's out on?
That's what we're just going to get right now.
Your Honor, his case number is 17-11331 CF10A. What's that? 17-11331 CF10A.
There's somebody else here that wishes to address?
My name is Detective Selma Vigo from the Seminole Police Department. I was the arresting officer involved in the case. So I just wanted to bring to the court's attention his extensive criminal history. And also this case started by investigating a armed robbery where the victim ended up not wanting to go further with the case.
I saw that in the probable cause affidavit. And what I have here is a grand theft auto. I do find probable cause on the grand theft auto. He has numerous no bond holds, both with the possessions of cocaine and with the out of state hold. So I don't really feel a need to increase his bond on the grand theft auto at this point. Basically considering that he is already being held no bond on at least 3 other counts. So I'm going to leave the bond on the grand theft auto at $1,000, and the other counts will be no bond. Okay? Thank you, Detective.
Judge, if we could go back to Miss Stevens over in North Broward.
Sure.
I have had an opportunity to speak with her. Again, Judge, this is she's in North Broward, Judge. Yep.
It's a trespass.
Right, and Judge, she expressed to me that if the court would be willing, she'd be more than willing to plead no contest to resolve this matter.
Okay, let me find out. Ms. Stevens, I'm looking at her booking sheet. She's got a lot of aliases, so I'm assuming that she's got priors, but maybe I'm assuming wrong. State she have priors?
I'm sorry, Your Honor. Do you have can I just ask for her BCCN number?
Oh, sure. That is 778719.
19?
19.
Okay.
Mr. Lawrence, do you have other ones? This morning
Sorry, Judge?
I ran through these pretty quickly this morning. Do you have other cases? Okay.
there's one potential issue I just need to confirm.
Sure.
Okay. Just a lot of trespasses in the past.
All right, if she's interested in resolving the case today, I would adjudicate her guilty and give her credit for time served.
Judge, she expressed that that's what she'd like to do. So, Ms. Stevens, the court has offered you a time-served sentence in exchange for a plea of no contest. Is that what you want to do?
Yes, sir.
All right, ma'am, if you could raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, can you state your full name, please?
Shivra Morgan Stevens.
Okay, Miss Stevens, you can put your hand down. All right, I indicated that if you want to resolve the case today, I would adjudicate you guilty, give you credit for time served. Is that something that you want to do?
Yes, sir.
All right, how do you wish to plead, guilty or no contest?
No contest.
All right, I'll accept your no contest plea and sentence you to an adjudication with credit for time served. Good luck to you, ma'am.
Thank
All right. Thank you, Judge.
There were two. Jamie Bradbury, I'll get you there. Ms. Bradbury, you are charged with one count of violation of probation on a felony count. I do find probable cause. You're being held no bond. You do have a status conference set on the 27th of this month at 8:45. Good luck to you, ma'am. Amanda Smith.
Ms. Smith is here, Judge, at Maine, she's approaching.
Okay.
Oh, I thought you were coming.
Morning, Ms. Smith. You are charged with petty theft, second degree, a third or subsequent offense. I do find probable cause. Your bond on this case is $750.
Judge, respectfully, and speaking with Smith, unfortunately, at this time, she's indigent. She doesn't have a job, but she has no sort of financial income, no money in the bank, nothing like that, nobody that can potentially post her bond. Judge, this is a nonviolent offense. She's homeless. She lives at the homeless shelter, which is at the Salvation Army. She said she could receive mail there. Considering this is a nonviolent offense, Judge, would you consider releasing her ROR standard pretrial? You can go ahead and dictate the terms of pretrial. You can tell her to come to pretrial once a week or once a month and call in once a week. And if she doesn't abide by your rules, there's going to be a warrant issued for her arrest.
Judge, if I could also, just to kind of piggyback onto what Mr. Romero's saying, the facts of this case are that she went to get a meal and eat it. It was simply a meal. Not that I understand that that's something that, according to the probable cause, she shouldn't do, but she wasn't stealing beer. She wasn't stealing any kind of clothing or anything like that. She was simply hungry and needed something to eat. So I would strongly ask the court to consider RORing in this case.
Apparently, your client declined pretrial supervision.
I know, I don't know what was the conversation she had with pretrial. I'm just, right now, I've had an opportunity to speak to her. Maybe she changed her mind. I'm not saying anything that that pretrial is saying incorrectly. But, Judge, she was trying to get a meal, maybe not pretrial, then a straight ROR. I was thinking, because it's a felony offense, probably the court wouldn't be inclined to a straight ROR. So that's why I was suggesting pretrial, and you dictate the terms.
Here's the problem. I think it's telling that your client didn't want pretrial services, which to me means that she would not be able to abide by the terms of pretrial services. At this time, I'm going to decline to put her on pretrial because I just don't want to set her up for failure at this point and cause more problems. So for right now,
That would be her staying in jail.
yeah. I mean,
I know your court's concerned as far as setting her up to fail, but the alternative is her in jail.
right, and honestly, she had the opportunity to sign up with pretrial services, and she declined that. So at this point, she's going to be there, and she'll come up later, and maybe she'll change her mind at that point. But at this point, her bond is $750. Jane Lashman.
No problem.
Ms. Lashman, you were charged with robbery by sudden snatching and battery on a person 65 years or older. I do find probable cause as to both state ship priors.
Yes, Judge. Her criminal history includes 2016 possession of cocaine. She was sentenced to 270 days county jail. Theft last year, possession of alprazolam, 2012. Felony prostitution, 2010. Prostitution, 2010.
All right.
Cocaine, 09. Theft, 08.
All right, ma'am. Having found probable cause as to these charges, I set your bond on count 1 at $5,000, count 2 at $5,000. Good luck to you, ma'am.
And Your Honor, stay with a request, or Ms. Lashman,
Yes, yes,
we'd ask for no victim contact.
Yeah, and there'll be no victim contact.
yes, I'm aware. Thank you.
Okay. Margot Militello?
No problem, Your Honor.
Ms. Militello, you are charged with 1 count of violation of probation on a felony charge. I do find probable cause. You are currently being held no bond. You do have a status conference set for the 27th of this month at 8:45, which is a week from Monday. Good luck to you, ma'am.
Thanks.
Derek Keener?
All right, Your Honor.
Mr. Keener, you're charged with a capias on a traffic failure to register a vehicle. Is this the only? No, this is an ad charge.
I'll check though, see what ones it's 6 is. He's got, no bond holds, violating a no contact order, a no bond on domestic violence battery, but I'd offer him a withhold if he wants to resolve it.
Okay, sir, if you wanna resolve this case today, the state's offering you a withheld adjudication, credit for time served, basically. Is that something you wanna do? All right, can you raise your right hand, please? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, can you state your full name, please?
Derek Keener?
All right, Mr. Keener, I indicated to you that the state has offered you a withheld adjudication with taking judicial notice of the credit for time you've already served. Is that something you want to resolve your case to today?
Sir.
Okay, how do you wish to plead? Guilty or no contest?
No contest.
All right, I'll accept your no contest plea and I'll sentence you to a withheld adjudication, credit for time served. Good luck to you, sir.
Thank you.
Kevin Van Dunk?
No problem, Your Honor.
Yeah.
Good morning, Mr. Van Dunk. You are charged with 4 municipal ordinance warrants, capiases. I do find probable cause as to all of them. Your bond is $100 on each one of them. State, is there anything else holding Mr. Van Dunk?
I just need his, BCCN number.
Sure. It's 882172.
From what I can tell, just these 4.
All right, Mr. Van Dunk, if you want to resolve these cases today, I would resolve all these with an adjudication with credit for time you've already served. Is that something that you were interested in doing?
Yeah.
Okay, sir. Then raise your right hand, please.
Okay.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
What did I get? My mom paid the bail.
Oh, you want it? Okay, you want to just make bail?
Yeah, I'll just make the bail.
Okay, then it's $400, sir. Good luck to you. Harold Dow?
No problem, Your Honor. He's in a wheelchair.
Okay, no problem. Good morning, Mr. Dow. You're charged with 1 warrant on a traffic criminal offense. I do find probable cause. Your bond is $250. Is this the only one holding Mr. Dow?
Yes.
All right. Mr. Dow, if you want to resolve this case today, I would offer you an adjudication credit for time served.
Yes, sir.
Is that something you want to do?
Yes, sir.
Okay, can you raise your right? Sir, I'm sorry. Did you, go ahead.
Yes.
Okay, raise your right hand, sir. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, you can put your hand down, sir. What's your name?
Arnold James Dow.
All right, Mr. Dow, I indicated to you that if you want to resolve this case today, I would adjudicate you guilty and give you credit for time served. Is that something that you want to do?
Yes, sir.
All right, sir, how do you wish to plead, guilty or no contest?
No contest.
All right, I accept your no contest plea. I'll sentence you to an adjudication, which is a conviction, credit for time you've already served. Good luck to you, sir.
Thank you.
Arthur Putman.
Mr. Putman's here, present judge at Maine.
Mr. Putman, you were charged with 1 count of possession of cannabis, less than 20 grams. I do find probable cause.
Judge, I'd ask you to consider straight ROR. He's 65 years old, been living here about 45 years now. He's collecting disability. He lives with his daughter in Sunrise. He's a Navy veteran. He served in Vietnam. Judge.
Where were you in Vietnam, sir?
Hello?
Where were you in Vietnam?
In 69,
Okay. Okay.
South Vietnam.
In South? I'm sorry?
South Vietnam, sir.
Okay. All right. I'm sorry, sir. I didn't mean to interrupt you. You were saying he's 65 and.
Judge, I know he told me he had a record. He said he had his rights restored, so he's no longer a convicted felon. I'm just thinking, Judge, would you consider an ROR on Mr. Putman's behalf?
Your Honor, he does have prior felonies. He's been to state prison. He has prior failures to appear. The state's offer, if Mr. Putman wants to resolve this, would be a withhold court costs, additional notice of time served.
He read my mind. Does he want to resolve it to a withheld in court costs?
I can ask him, Judge. Judge, he wishes to state's office.
Okay. Mr. Putman, can you raise your right hand, please? You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, sir. Sir, the state indicated that if you want to resolve your case today, that they would offer you, and I would approve a withheld adjudication with credit for time you've already served. So that's not a conviction on your record. Is that something you want to do?
Yes, sir.
Okay, how do you wish to plead, guilty or no contest?
No contest, Your Honor.
I'll accept your no contest plea. I will sentence you to a withheld adjudication, credit for time you've already served, and I'll waive court costs and fines. Good luck to you, sir.
Thank you, Your Honor. Thank you.
Thank you for your service. Judner Rosemond.
Mr. Rosemond's here at Maine Jail.
Mr. Rosemond, you are charged with 1 count of petty theft. I do find probable cause.
Mr. Rosemond's going to inquire if Your Honor would consider resolving his case. My understanding is, I believe it's at a Home Depot and the merchandise was recovered, so I don't think there's any outstanding restitution matters. He wants to resolve, he wants to, it's going to be his birthday pretty soon, Judge. He wants to try and resolve his case today.
Birthday's on Friday.
Yes, sir.
What's his record, if any?
He has a record.
Disorderly conduct, resisting without violence a couple months ago, PVP 2015, PVP 2015. Possession of carrying concealed weapon, resisting without violence 2014, resisting without violence 2013. Delivery of cocaine 2012.
I'm going to let Mr. Rosemond post a $100 bond.
Yes, Judge.
Good luck to you, sir. Willie Grayson.
Mr. Grayson's here, present, Judge. It's a municipal case.
Okay, Mr. Grayson, you're charged with 1 count of acapius on a misdemeanor open container violation. I do find probable cause. Just looking at his booking sheet, he's got a number of different aliases, so I assume that there's some prior arrest. But assuming that, Mr. Grayson, if you want to resolve your case today, I would adjudicate you guilty, giving credit for time served.
Yes, Your Honor.
Okay, can you raise your right hand, Mr. Grayson? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, Mr. Grayson, you can put your hand down. I indicated that I would adjudicate you guilty, give you credit for time served. That's something that you want to do, correct?
Yes, Your Honor.
All right, sir, how do you wish to plead, guilty or no contest?
No contest.
I will accept your no contest plea, adjudicate you guilty, give you credit for time you served. Good luck to you, sir.
All right, sir. All right, thank you, Your Honor.
Benjamin Madamba.
Come on up, sir.
Sir, you're charged with 3 counts. First is possession of cannabis less than 20 grams. The second and third are violations of probation on a misdemeanor charges. I do find probable cause as to all of them. On count 1, it's a $100 bond. On counts 2 and 3, it's a $2,500 bond apiece. So your bond is $5,100. Good luck to you, sir.
Check and see if you had any questions for it.
Quasi Simpson.
Judge, who did you call?
Mr. Simpson. Quasi.
Mr. Simpson's here on Main.
Okay. Mr. Simpson, you were charged with 1 count of a warrant on a misdemeanor traffic offense. I do find probable cause. Your bond is $250 on that case. Good luck to you, sir.
Mr. Simpson's going to inquire if you would consider resolving this case today.
Looks like this would, let me see. Looks like this would habitualize him.
This would habitualize him, and I think it's probably in his best interest to post a bond. I don't necessarily want to take a plea on something that's going to habitualize him. So I'm going to let him post a $250 bond. Good luck to you, sir.
Judge, I understand the court's concern in that. I didn't know that, so that would be my concern. I agree with the court. Would you consider then releasing him on pretrial?
What's Mr. Simpson's prior record?
One moment here.
Does he have a place? Does he have a place to stay?
No, he's homeless, Judge.
All right. I mean, I just don't think that that's going to be.
I understand.
You know.
I understand. Thank you, Judge.
No problem.
You'll be going to court November 17th, which is in 2 days on Friday, okay? Good luck, sir.
Jovenel Benoit.
I've been informed he bonded, Judge.
Okay. George Storoshenko.
Mr. Storoshenko, come on up, please. Yes, Storoshenko. Judge, this is a county ordinance case.
All right, Mr. Storoshenko, you were charged with 2 warrants on county ordinances. I do find probable cause. Your bond is $25 apiece. I'm not sure what county ordinance it was.
I know the charge number 1 is panhandling. I'm just
Okay.
checking to see if it's the same.
All right. Mr. Storoshenko, if you want to resolve your case today, the 2 cases, I would adjudicate you guilty, give you credit for time served. Is it?
That's good, yeah. Guilty. No contest.
You're jumping the gun, sir. I appreciate that. But can you raise your right hand? You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What's your name, sir?
George Storoshenko.
Okay, so I pronounced your name right. I'm proud of myself for that one. Okay, sir, I indicated to you that that I would adjudicate you guilty, give you credit for time served on both these counts. Is that something that you want to do?
Yes.
Okay, sir, then how do you wish to plead, guilty or no contest?
Guilty.
Okay, I will accept your guilty plea, and I will sentence you to an adjudication, credit for time served, to run concurrently on both counts. Good luck to you, sir.
Before we go to the next case, nothing on this case.
Okay, good luck to you, sir. You're done.
And I apologize, I meant to bring this up before we started the docket. We have a case this afternoon that's up for a motion to release. That's actually an executive assignment. I spoke to the ASA from Dade County. He's going to be anticipating making a request for an extension of 40 days. I just wanted to ask on his behalf, would the court have any issue with contacting telephonically for the
No,
hearing?
that's fine.
Okay, I'll let him know.
Yep, that's fine. Michael Miller, you're done, sir. Morning, Mr. Miller. You were charged with 2 counts. The first is driving while license suspended, first offense. The second is a warrant on a traffic criminal case, which looks like it's a suspended driver's license offense. I do find probable cause as to both these. Your bond on count 1 is $100. Your bond on count 2 is $2,500.
Judge, in speaking with Mr. Miller, we also wish to ask the court if Your Honor would consider resolving this case today.
What division is MA?
Judge Brown. And this, Your Honor, I don't know what request was made, frankly, but I can tell you, I'm looking at his driving record. I see a DWLS conviction, or withhold, but it still counts, out of date in January 13, 2016. So these two would result in a habitualization.
I'm going to let him go before Judge Brown on these cases, because it appears that if I take resolve this matter today, then it will result in a habitualization on his record. Yes.
In that case, Mr. Miller then asked me to make the request if you would consider pretrial. He does have an address. He lives in Miami Gardens with his sister, and his sister would be, normally she would be in a position to bond him out. She's a secure. However, right now, from what he's told me, that there is some sort of emergency, so right now all her salary is going to pay for some outstanding medical bills. So right now, she doesn't have the financial capability of buying him out. Would you consider pretrial if pretrial can verify his address?
I know these aren't the most serious charges, judges, but I don't think he's a good candidate for pretrial, considering he didn't show up in court, and then he gets arrested on the capias, allegedly committing the same offense that he was out on.
What does he have, like a
One moment.
prior record?
I'll check. No, it would appear all of his prior arrests out of Dade County were dropped. On his driving record,
What does pretrial say?
If the court orders us to take him to trial, the fact that count 2 shows that he's already guilty of there, you don't believe him.
his license he's had his license suspended for failing to appear in court more than once.
Judge, I know
I've seen
I
four.
don't know if he spoke trial, but he's more than eager to speak to pretrial and give them whatever information they need. And
Well, these are not the most serious offenses, given what we deal with, so I will ROR him a pretrial.
If he could put his address on the record.
I'm sorry?
Put his address
Yes,
on the record.
we need to have his address on the record for pretrial.
so pretrial's going to come and talk to you. They're going to get the
No,
information.
put his address on the record right
No,
now.
we
Then you'll be released pretrial.
Hector, we need his address on the record now.
Oh, okay. Say your address on the record.
My address is 16830 Northwest 7th Avenue Road, Miami Gardens, Florida, 33169-5312.
16830 Northwest 7th Avenue Road, Miami Gardens.
Deputy, this is
And the zip code?
33169-5312.
If you could just repeat that.
33169, he said?
The address?
No, just
Repeat the whole address.
I have
16830 Northwest 7th Avenue Road,
I have
Miami
it.
Gardens, Florida, 33169.
Telephone number.
5312.
And a phone number, sir.
3169.
And a phone number. Yep.
Phone number.
05-624-7981. That's my house phone.
Does your mom have a cell number? Or I mean,
What's her name?
Sister. Yeah, what's the name?
What, that's the house?
What's the mother's name?
Here you go. Meriel Seymour, Seymore.
And the court is placing him on pretrial in both cases?
Yes.
Okay, I'll prepare 2 court orders. He must report to the pretrial office today between the, as soon as he's released. And we all know he's not supposed to drive without a valid license. He may not know, but if the court could just let him know.
Right. You're going to have to report to pretrial when you are released, and obviously, if you commit a new offense, which includes driving without a license or any kind of traffic criminal offense, then it'll be a violation of your pretrial, and you'll be back here on a no bond hold. Do you understand that, sir?
Yes.
Okay. All right then.
As soon as now, you're gonna have to go to pretrial, and they're gonna give you a map right there, okay? TJ, can you give this gentleman a map? Thank you, TJ.
Lawrence Davis.
Conti?
Good morning, Your Honor.
Good morning, sir. You are charged with 1 count of warrant on a felony charge. I do find probable cause on that. You were being held no bond. I mean, I'm sorry, you were being held on a $1,000 bond on that.
And I just want to advise the court, on counts 1 and 2, they were felony charges, but he resolved them to, from what I can tell, to be, being placed on probation, so.
Yes, is there any way I can, resolve this, count 3 today, or run it concurrent with, count 1 and 2?
Well, I cannot resolve your case today.
And that's why I was bringing the court's attention, because I imagine if this case is resolved, it'll probably be resolved in the same fashion as counts 1 and 2. Not
Sorry.
to resolve it, but for the court's consideration for release purposes.
Was this like a not in custody?
This is not in custody, yeah.
Oh, I see. All right.
Judge, if I could add, and the court may be inclined to do this, but if the court would just ROR him on this count, he's already going to be under the supervision of probation anyway for the other case, so.
Right. All right, sir, you obviously you're on supervision right now, correct?
Yes, sir.
And you're living you have a place to live, correct?
Yes, sir.
All right. How long has he been on probation?
It was probably, I would imagine he was placed on probation recently. There you go.
Okay. All right. Have you met with your probation officer?
Well, as soon as I'm released, I'll be meeting them.
All right. I'm going to ROR you. You're already on supervision. I imagine this is going to.
And I don't know if Mr. Davis already knew this. He's got a status conference scheduled for the 21st, 8:45 before Judge Howery.
Okay. So,
Correct.
all right. So you're aware of that.
Yes,
Okay. Good. Don't miss that. I'm going to ROR you.
not a problem. Thank you, Your Honor.
No problem. Valentino McFarland.
Conti?
Good morning.
How you doing, Mr. McFarland?
Good.
You are charged with 2 counts of 2 counts: robbery without a firearm and grand theft. I find probable cause. These are counts 5 and 6.
And I can advise, I remember Mr. McFarland's other cases. He's being held on 2 other strong arm robberies, one with an aggravated battery. His total bond's $20,000 on those. He's also being held, he had his bond revoked on a penny battery. The other strong arm robberies, it's the same type of fact pattern. Multiple people essentially mugging an individual in the Wilton Manors area.
Judge, I know that, well, I guess he's being held no bond from what the state said, but I know that when I spoke to him earlier, he indicated that his other bond is like $20,000. So I would just ask the court to set a reasonable bond in this case.
All right. I'm going to set bond on this case at $7,500
I'm sorry.
for count 1 and $1,000 on count 2.
And we just request no victim contact.
No victim contact.
Thank you.
Yes.
Okay.
That's it?
Yep, that's it.
I don't know if he was in charge of this the first time through.
Daniel Ritz.
Mr. Ritz is at North Broward. Judge, I just spoke to Mr. Ritz on the telephone. I can indicate this information to the court. He's 46 years old, that he is single, that he was working previously, but he was shot in this case in the belly. He was in the infirmary he's in the infirmary now, but he was in the hospital for a long period of time. He asked me what basically the facts of the case were. I'm missing the last page of the probable cause, so I have to read that, but I don't know if the court could just inform him basically of why he's the one that's being charged since he was the one that was shot.
Well, in reading this probable cause affidavit, Mr. Ritz, it appeared that you were being evicted from your apartment, and the landlord was standing by. And according to the probable cause affidavit, at some point you went back into the house, having been evicted from it. And when he went to confront you with regard to that, he was attacked with a hammer, sustaining injury with that hammer, and he then shot you.
And Your Honor, I can tell you, we actually, when Mr. Ritz was first arrested, he was charged with burglary of a dwelling and misdemeanor criminal mischief. We declined the burglary dwelling. We upfiled the criminal mischief to a felony. He's got a $500 bond on that. I advised Judge Benson when the $500 bond was set. My cause for concern, based on these allegations, is the fact that Mr. Ritz has been convicted 3 times in the past for stalking, one of which was an aggravated stalking where he violated his probation, was sentenced to just over 2 years state prison. Excuse me, the most recent stalking was a misdemeanor in 2014. And so I think my concern is obvious. These are not 2 strangers. There's 2 people that are known for each other. And Mr. Ritz has a history of going after people repeatedly, even after being told not to.
Right. Well, I mean, I read the probable cause affidavit, and I think Mr. Ritz got a break when he didn't die after being shot, because the injuries to the victim in this case are consistent with his story and being attacked with a hammer. And based on the probable cause affidavit, I'm setting the bond at $25,000.
Judge, I know that he won't be able to afford that. Would the court consider anything else lower than that? I know that, like I said, he's lived here basically all of his life, and he again was a victim because he was shot, in the sense that...
Respectfully, sir, he was the assailant, and he was lucky that he did not die that night. And no, I'm not going to consider
He shot me after I
And
moved out.
Your Honor, even though I believe Judge Benson ordered it, but I don't know if he was present when she ordered the no victim contact. So
I'm sorry, no victim contact
you,
is
Judge.
also on the probable cause. So, good luck to you, sir. Christopher Glass? I'm sorry? Oh, okay, I'm sorry. Christopher Glass? Good morning, Mr. Glass. You were charged with 2 counts, uttering a false instrument and fraudulently using an ID of another person. I do find probable cause. This is an ad charge?
Yes, Your Honor. He's being held on a felony theft for a $750 bond. He's gone to prison in the past HO for grand theft, burg dwelling. I'm just asking that the the standard bonds be kept in place on these charges.
Yeah, your bond on count 1 is, well, actually it's count 4 is $1,000. Your bond on count 5 is $1,000, and I'm going to leave those in place. Good luck to you, sir.
Judge, just for clarification, I know Mr. Linder said he's being held on a $750 bond, and I look in the docket, and this is in reference to count 4 and 5. What's 2 and 3?
Counts 2 and 3 are resisting without violence and trespass, and no bonds were attached to those, or he was ROR'd either way.
Okay, so 2 misdemeanors. Okay, I got you. And Judge, and Mr. Glass is requesting me to ask your Honor, if you would consider releasing him on pretrial.
No, sir.
No, sir.
No, sir. Good luck to you.
Demetrius Richardson is here present, Judge?
Yeah, Demetrius Richardson. All right, Mr. Richardson, you are charged with, looks like 2 ad charges. Count 7 is aggravated assault with a deadly weapon, which I believe is, and then aggravated battery with a deadly weapon.
Your Honor, Mr. Richardson was just before Judge Cohen I think yesterday actually. On a unrelated matter for burglary with assault or battery, domestic violence, battery, possession of methamphetamine, false imprisonment, and resisting without violence. He's being held no bond on the burglary with assault or battery. He's got $3,500 bonds on the battery, the false imprisonment, and the resisting without violence. He's also being held no bond for a violation of probation on possession of cocaine. He in 2010, he pled out a felony to a misdemeanor battery, 2010 possession of cocaine with intent, and assault on a law enforcement officer.
All right, well, in reviewing the facts of this probable cause affidavit, and even in light of the fact that he's being held no bond on other counts, I'm setting bond on each one of these counts at $10,000. So it's a total of $20,000 on count 7 and 8. Good luck to you, sir.
We just asked for no victim contact, Judge.
And no victim contact.
Thank you.
Contact goes without saying, but I'll say it anyway. Ramon Fuertes.
Mr. Fuertes is here.
Good morning, Howard.
Good morning. Sir, you're charged with 3 counts, violation of probation on a felony, and then an out-of-county hold on count 3, and then there's a capias on a misdemeanor warrant on count 2. I do find probable cause as to all of them. Counts 1 and 3, you're being held no bond, and count 2 is a $500 bond. Just trying to see where the out-of-county is from.
Thank you, Judge.
Good luck, sir. You have, it looks like you have a status on the felony BOP on the 21st, which I believe is next Tuesday, or Wednesday, I forget which, at this point, but, and then there's one on the 27th, I think, for the misdemeanor. Good luck to you, sir. Jesus Nunez.
Dear President, Judge Amin.
Mr. Nunez, you are charged with 2 counts, burglary of a dwelling while armed and grand theft. I do find probable causes to both of those.
And, Your Honor, on count 1, the state would be seeking no bond hold on the punishable by life offense under Isaza v. State. The elements, the allegations would satisfy the elements that Mr. Nunez Arias armed himself with a firearm while committing a burglary of a dwelling. Noting, Your Honor, the strength of the evidence that 3 separate witnesses, one of which was the alleged victim, observed Mr. Nunez Arias with the firearm in his possession. 2 observed him right outside the room, the alleged room that was broken into. 1 saw him leaving the room. The victim saw him in the area of the burglary and identified the gun that was in his possession as his. Both the witnesses saw him with the firearm. He confessed, one moment, Your Honor, that he was in the room, Your Honor, and additional property that belonged to the victim's girlfriend was located in the defendant's possession.
All right, I will hold him no bond
Yes, Judge. Judge, we would object to the finding of proof evident presumption grade. As the court knows, that's the greatest standard that there is out there. It's higher than even beyond every reasonable doubt. Based on the fact that the probable cause affidavit is just that, it's something to lay out what the elements of the crime are. We haven't had any testimony from anybody. There's been nobody here to inform the court anything more than is contained in the probable cause affidavit. Because of that, we don't believe you can meet that higher burden of proof evident presumption grade, and because of that, we would ask the court not to find proof evident presumption grade.
Is the defense asking me to have an Arthur inquiry, or go ahead? What would...
No, Your Honor, because this is an adversarial, but what I'm indicating to the court is we would argue that you shouldn't be able to find it just based on a probable cause affidavit. If the court were to find proof evident presumption grade, I would ask that the court use its discretion to set a bond in the case.
And Your Honor, I don't know if the court has previously had an opportunity to read the Isaza case. If you haven't, I have it. But the 4th TCA is very clear in Isaza that the state can rely upon a problem, and which relied upon Brackett v. State, which is also out of the 4th TCA, that the state may rely upon a probable cause affidavit or affidavits to satisfy proof evident presumption grade. To rule that a probable cause affidavit, or this probable cause affidavit, that the state can't rely upon it would essentially be going against the
It's
rulings
sworn.
in
It's
Isaza.
it's sworn to, and I believe that the case law is pretty clear that you can rely on a probable cause affidavit, and I think that the probable cause affidavit sets out some pretty strong evidence against Mr. Nunez, and I'm going to hold him no bond.
And in an abundance of caution, Your Honor, we just ask for no victim contact, no return to the incident location.
And the court's keeping $1,000 on count 2?
Yes.
Thank you.
And Your Honor's ordering the contact, no return, no contact, no return?
Yeah, no victim contact, no return to the location.
Thank you.
Christopher Pierre?
Mr. Pierre is present, Judge. He's approaching. He defines the service of public defender.
All right, Mr. Pierre, you were charged with 4 counts. The first is grand theft auto. The second is operating without a valid DL. The third and fourth are violations of probation or community control. I do find probable cause as to all 4 of them. Count 1 is a $1,000 bond. There's a 0 bond on count 2. Counts 3 and 4, you're being held no bond. You do have a status conference on counts 3 and 4 on the 20th of this month, which I believe is Monday at 8:30 in the morning in front of the division judge. Good luck to you, sir.
Harding?
Lane Harding. Mr. Harding, you are charged with 2 counts. The first is possession of cannabis less than 20 grams. And then the second is violation of probation or community control. I do find probable causes to both those counts. Count 1, there's a 0 bond on it. Count 2 is a no bond hold. I don't have a status date on this one yet. But,
It's actually, I believe he's on probation in another state. He had a transfer down here.
oh, I see. Okay. That's great. I see it now. Okay. All right, so your status conference will be set, sir. Good luck to you.
Thank you.
Rule Duget.
He's approaching, Judge.
How do you pronounce your name, sir?
Brooks, Duge.
Okay. Ms. Duget, you are charged with 1 count of violation of probation on a felony, and I do find probable cause. You are being held no bond on that case. Your status is set on the 27th, which is a week from Monday at 8:45. Good luck to you, sir. Ryan Williams.
Mr. Williams is approaching, Judge. He's declined the services of public defender.
Mr. Williams, you are charged with 4 counts. The first 2 are aggravated assault with a deadly weapon. The third is carrying concealed firearm, and the fourth is firing a weapon or discharging a firearm on school property. I do find probable causes to all 4 counts. State.
Your Honor, Mr. Williams, his only prior was an old juvenile misdemeanor. Really, my concerns about this case are more about the allegations. Your Honor, based on these allegations and my concern for the safety of the community, noting that just based on the addresses that Mr. Williams lives very close to this school that's mentioned in the report, I'm going to be asking for $15,000 bonds on counts 1 and 2, $5,000 bond on 3, $10,000 bond on 4, no victim contact, no return to the school, the Catholic school, the St. Helena Catholic school that, one moment, Your Honor, is located at 3340 West Oakland Park Boulevard in Lauderdale Lakes. And should Mr. Williams post his bond, he'd be supervised by pretrial release with a GPS monitor, with an additional condition that he not be in possession of any firearms or weapons during the pendency of this case.
Ma'am, are you here for Mr. Williams?
Yes, I am. I'm Ryan's mother.
What's your name, ma'am?
Katina Williams.
Okay.
He was close to the school because he was trying to get home, and someone was following him, and that's what happened. He was running and trying to gain leverage, and that's what happened. I do understand about the school, but also, as far as with the bonds, I am on disability, so those bonds are
They're high.
high.
Yep. Yes, ma'am. Here's the situation. In reading the probable cause affidavit, my concern is that I'm not sure what was going on here, but what I do know is that your son fired a number of shots at people. And we're lucky that nobody was hit because we would be here on a different matter if that was the case. But I take weapons charges very seriously, I think as most people do in my situation. This is about as serious as it gets without having somebody injured.
I think they said they were in the air. It's the same, I understand what you're saying, but
Yeah, those bullets come down somewhere and you're putting people at risk, and there's no reason to be playing with guns like that. So
Right.
I'm setting bond on count 1 at $20,000, count 2 will be $20,000, count 3 will be $1,000, and count 4 will be $5,000. It's a total of a $46,000 bond. And then if the division judge hears testimony differently, they are certainly welcome to alter that bond in any way, but the way I see it right now, for the protection of the community, this is the appropriate bond. Good luck to you, sir.
So 46,000.
46,000.
That's what I would have to give for him to.
Well,
bond out.
that's something that you can talk to a bondsman about, but I don't get involved with that.
And that would be, he wouldn't qualify anything for anything like pretrial or anything like that.
No, ma'am, not on the circumstances of this case, not right now. But that could change with the division judge.
And, Your Honor, just, I'm sorry, just with respect to the other request, I just need to know if the court is denying.
I'm sorry, I can't.
Just with respect to the other requests that I made, I just need to know if the court's not imposing those conditions, or?
I don't see any reason why not. If he bonds, I'll put him on pretrial with a GPS monitor.
And including no return to the property of the school, no victim contact, no firearms or weapons?
Well, it goes without saying that he will not be allowed to have any firearms or weapons. As far as returning to the school, I don't think the school was the draw here. I'm not going to put that he lives near the school. The GPS will be.
Well, I guess, and I'm not asking, is he a student there?
Ma'am, is he a student at that school?
No, he isn't.
I'm not saying that he can't come within 500 feet. I realize his house might be. I'm just saying he can't go on to. If he's not a student, then there's really no reason for him to go into
All
the
right.
property.
Yeah. I mean, no return to the school. There's no reason for him either.
It's allowed, it's like a daycare.
Thank you, ma'am. All right, good luck to you, sir. Walter Lewis.
Hold on one second, Judge.
No problem.
Judge, I've been informed he bonded.
Okay. Yeah, I Nicholas DePass.
Mr. DePass is approaching, Judge. He declined service to public defender.
Okay. Mr. DePass, you are charged with 2 counts of violating community control and a felony charge. I do find probable causes to both of those. You have a status conference on that violation on the 27th at 8:45. Good luck to you, sir.
On what date, sir? George, I'm sorry?
On the 27th, which is a week from Monday.
At what time?
At 8:45.
All right, thank you.
No problem. Good luck to you, sir. Anthony Flynn.
Mr. Flynn, come on up.
I'm sorry? Hold on one second.
Anthony? I'm not getting a response.
He's not in there, Hector.
Oh.
Okay. Michael Green.
Don't send her yet.
Mr. Green is here, present, Judge?
Community control, everything else is still the same.
Okay. All right, sir, you're charged with 1 count of violating of community control. I do find probable cause. You're being held no bond on that charge. It looks like you have a status conference set on the 28th, which is a week from Tuesday at 8:30 in the morning in front of your division judge. Good luck to you, sir.
That's violation of probation, that's violation.
Ryan Cook.
He's here, present, Judge.
Mr. Cook, you have eight counts. The first is burglary of an unoccupied structure. The second 2 are probation violations. The 4th is resisting an officer without violence. 5 and 6 are violation of community control, and 7 and 8 are violation of community control on felony charges. I do find probable causes to all 8 of these charges. See any input on counts 1 and 4?
I'm fine with whatever the court deems appropriate.
All right, well, he's,
Judge, considering he has a no bond hold, yeah, there's not much we can do.
yeah, I mean, I will set a $1,000 bond on count 1, and I'll leave the bond on count 4 at 0. So you were being held no bond on 6 of the 8 charges. The other one will be a $1,000 bond. So you do have a violation of probation hearing on Monday at 8:30 in front of your division judge. Good luck to you, sir.
Good luck, sir.
Tony Davis.
Mr. Davis is here present,
And,
Judge?
Your Honor, if I could be heard
Yes.
before, and I'm sure the court already probably noticed this, this actually reads more as a robbery by sudden snatching.
Yes.
Yeah.
All right, sir, you are charged with 1 count of, well, it's robbery without a firearm, and then an out-of-county hold. In reading the probable cause affidavit, and the state pointed it out, but I read the probable cause affidavits, and it's really a robbery by sudden snatching, so I find probable cause for robbery by sudden snatching. And I do find probable cause on the out-of-county hold. The out-of-county hold, you were being held on a $5,000 bond. State, any input on the robbery by sudden snatching?
Just to advise the court, one, the out-of-county hold, it does appear to be a domestic violence in nature. At a Broward, at a burglary in 2012, resisting without 2012, resisting without 2011. Oh, I'm sorry, in 2012, sale, delivery of cocaine at a near park.
All right.
Judge, in speaking with Mr. Davis, he's not working right now. He's going to school. He goes to Sheridan Tech. He's studying AC. He sometimes volunteers for the Boys and Girls Club here locally in Fort Lauderdale. He's been here his whole life. Judge, I know you can't touch count 2. He lives with his mom. She's a single mother. He doesn't even think she'll be able to afford to post a monetary bond on count 2. Judge, I'd ask you to consider a $1,000 bond on count 1.
I'm gonna give him a $3,500 bond on count 1,
And, hold on, just ask for no victim contact.
and there'll be no victim contact.
Thank you.
Good luck, sir.
This one?
Cliff Carpinella.
I've been advised medical recess.
Solicitation email? Yep.
Richard Young.
He's here present, Judge.
Good morning, Judge.
Good morning. Mr. Young, you were charged with 8 counts, burglary of unoccupied conveyances on count 1 and 2. And counts 3 and 4 are possession of stolen driver's license or ID. 5 is driving while license suspended. 6 is possession of burglary tools. 7 and 8 are grand theft. I do find probable causes to all 8 of those.
I believe there's 9, 10, 11.
Oh, I'm sorry, you're right.
12, Judge.
And there's a co-defendant on this case too. Right. And then 9, 10, 11, and 12. 9 is petty theft. 10 is possession. 10 and 11 are possession of stolen credit cards or debit cards, and 12 is possession of cannabis, 20 grams or less. There is probable causes to all of the counts. Any input as to counts 1 and 2?
Your Honor, just to advise the court, it does appear that Mr. Young has a warrant, it's not extraditable, but a warrant for failure to appear on a marijuana case from September 12th out of Austin, Texas, out of state of Georgia. Another arrest for failing to appear, that was from 2015. Giving false name obstruction, 2013. Another failure to appear in 2012. Giving false name, criminal trespass, 2012. And he, out of the state of Florida, he did, it's from, one moment, it's from, I believe it's 2000, 2001. He went to prison out of Dade County on a burglary.
All right,
Judge, I'd ask you at this time maybe to consider setting, this is a third-degree felony. I'd ask you to consider setting bond on count 1 $1,000, bond on count 2 $1,000. I'd ask you to leave the others in place. He lives with his grandmother. She's retired. He doesn't think she's even going to be able to post that, but considering we're talking about almost a total of about a $10,000 bond. Judge, that's why I'm asking for 1,000 on 1, 1,000 on 2.
I'll set bond in the amount of $2,500 each on count 1 and 2, and then I'll leave the other bonds where they are. It's 1,000 on count 3, 1,000 count 4, 100 on count 5, 6, 7, 8 are 1,000, 9 is 100, 10 and 11 is 1,000, and 12 will be 100. Looks like it's a $12,300 bond. So it's $2,500 on count 1 and $2,500 on count 2. And all the other bonds. Good luck to you, sir. Willie Davis.
He's approaching.
Good morning, Judge.
Good morning. Mr. Davis, you were charged similarly with the last gentleman. You're charged in 11 counts. Counts 1 through 11, 1 and 2 are burglary of a conveyance. Counts 3 and 4, possession of stolen DL or ID. Count 5 is possession of burglary tools. Count 6 and 7, grand theft. Count 8, petty theft. Count 9 and 10, possession or receiving a stolen credit card or retaining stolen credit card. 11 is possession of cannabis less than 20 grams.
Yes, Judge, Mr. Davis is currently out on bond since April 6th of this year for burglary of a conveyance and theft.
Okay, is that out of Broward?
Yes.
All right. Finding a probable cause in this case indicates that he has violated the condition of his bond on that case, and I'm going to revoke his bond on that case.
And the case number is 173975 CF10A.
So in that case, his bond will be revoked and he'll be held no bond. I'm going to be consistent with the bond on this case. It'll be $2,500 on count 1 and $2,500 on count 2. All the other bonds will remain as the standard bonds that are listed. And anything else?
Nothing from the state.
Good luck to you, sir. Lawrence Perry.
Mr. Perry is approaching, Judge. He declined the services of public defender, Judge.
Mr. Perry, you were charged with 3 counts: obscene communication or using a computer to seduce or solicit, 2, traveling to meet or use a computer to lure a child, and 3, transmitting info harmful to minors. I do find probable causes to all those counts. State.
Your Honor, the state is going to be requesting on counts 1 and 2, $35,000 bond each, $5,000 bond on count 3. Your Honor, I spoke with, I just want to see if he wrote the report. Yes, Detective Mike Silver, who authored the probable cause affidavit. He advised me the alleged victim and her family are very concerned for her safety, noting that based on these allegations, at this time, Mr. Perry does know, based on the allegations, where she lives. I would also note, based on these allegations, that there's no reason to believe this is an isolated incident, since there were allegations involving similar activity with an undercover detective, the detective that was acting in an undercover capacity. So my concern isn't just limited to the alleged victim, but the minors in the community as well.
Does Mr. Perry have any priors?
One moment, Your Honor. All right, he's got numerous arrests out of the state of Michigan as recently as 2014. He was convicted in 2014 for possession of controlled substance. Everything else was, he also was convicted of 2 counts possession of controlled substance in 2012. Everything else was dropped. He was arrested in 2016 in Dade County for possession of firearm or weapon or ammunition by a convicted felon or delinquent adult or delinquent juvenile. That was dropped, though.
Given the allegations in the probable cause affidavit, I'm setting bond on count 1 at $25,000. Count 2 will be $25,000. Count 3 will be $5,000. In addition, if he is to bond out on these, he'll be on a GPS monitor. And there will be no victim contact, direct or indirect.
Oh, I'm sorry, Your Honor. Thank you. Your Honor, we'd ask for an additional condition that Mr. Perry not be in possession of any devices with access to the internet.
Oh, yes. Mr. Perry, you're not to be in possession of any devices, whether it be a smartphone or a computer or a tablet that have access to the internet.
And that he not be in contact with any minors, Your Honor. We'd also be requesting that.
And you're not to have contact with minors. Lucky, sir.
Can I speak, Your Honor?
It's probably in your best interest not to, because we're being recorded and anything you say will be used against you.
And Your Honor, just so you're aware, he will be coming back at PM. There were 2 charges in this case.
Okay. All right. I think you're probably coming back in this afternoon, sir. So I would recommend that you speak to your attorney. You've rejected the services of the public defender's office. But I recommend that you not say anything because what we're doing here is being recorded, okay? Good luck to you, sir. Yeah, correct. Correct. Orlando Cuervo Martinez.
Mr. Cuervo Martinez is approaching, Judge. He's here at Maine.
Okay. Mr. Martinez, you were charged with 1 count of possession of cocaine. I find probable cause.
Judge, Mr. Cuervo Martinez is homeless. However, he's been living here for 10 years. He does have a mailing address. So, Judge, I don't know if you would consider releasing him, considering this nonviolent offense, ROR.
Does he have any priors or failures to appear?
Checking, he does have priors. Checking to see if he has any failures to appear. He was arrested last year on a capias for theft, possession of heroin, and felony theft.
At this time, sir, I'm not inclined to ROR him. It doesn't appear that he's a good candidate for returning to court. So at this time, it'll be a $1,000 bond. Good luck to you, sir. Patrick Johnston.
Mr. Johnston is here, Maine Judge. He declined the service of public defender.
Morning.
Good morning. charged with one count of burglary with assault or battery.
And, Your Honor, assuming the court finds probable cause.
I do find
Okay.
probable cause.
Your Honor, I spoke with the alleged victim. The state is not going to be requesting a no bond hold at this time. Mr. Johnson has no criminal history. The alleged victim has no objection to the court issuing a bond and no victim contact order.
Ma'am, you're here on behalf of Mr. Johnson?
It's Mom.
Okay. All right. Anything you want to tell the court?
I don't know what happened. I just know he's been through hell the last 9 months with numerous tragedies, so I don't know if that has anything to do with it.
Okay. All right. State, what is the recommendation on the bond?
Your Honor, I was going to be requesting a $5,000 bond, no victim contact.
And that was to the alleged victim's satisfaction?
Yes.
All right. Given the representations of the state, I will set bond in the amount of $5,000 and order that there be no contact with the victim. Okay, sir. Good luck to you. Calvin Johnson.
Is here present, Judge Amain?
Mr. Johnson, you're charged with 3 counts. The first is grand theft. The second is false ID to a law enforcement officer. And the third is a capias on a felony charge. I do find probable causes to all 3. On count 1, your bond is $1,000. On count 2, it's a 0 bond. And count 3, you're being held no bond on the felony capias. Good luck to you, sir.
Judge, our only request would be, would you sign a phone order allowing Mr. Johnson to have access to his phone contacts?
Yes.
Thank you, Judge.
Donald Strickland.
Mr. Strickland, come on up, please.
Mr. Strickland, you are charged with 4 counts: corruption by threat, violation of municipal ordinance, violation of parole, and a violation of parole. I do find probable causes to all 4 of those counts. The corruption by threat, I'm going to set bond in the amount of $1,000. Count 2 is a 0 bond. Counts 3 and 4 are no bond hold.
Good luck, sir.
Good luck. Daniel Munoz.
He's going to be at medical reset. He was detoxing when I called out to North Broward.
Okay. Idris Matthews.
He's here, President Maine.
Mr. Matthews, you're charged with 2 counts of violation of community control and felony charges. I do find probable cause on both those counts. You are being held no bond on those counts. You do have a violation of community control status conference set for a week from Monday, which is the 27th at 8:45 in the morning. Good luck to you, sir. Samaj Taylor.
He's here, President, Judge. He declined the service of public defender.
All right, Mr. Taylor, you're charged with distributing or delivering cannabis and distributing to deliver cocaine. I do find probable causes to both those counts. Count 1, your bond is $1,000. Count 2, your bond is $2,500. Good luck to you, sir. Joshua Hanna.
I've been informed Mr. Hanna bonded.
Yep. It's not going to be there. Patrice, I just texted the detective. Yeah, I know.
Levy Carcamo.
Mr. Carcamo is here, President, Judge.
Mr. Carcamo, you are charged with a violation of probation and a warrant on a felony charge. I do find probable causes to both those counts, and you are being held no bond as a result. It looks like you have a status conference set for Friday, this Friday at 8:45 in the morning in front of the division judge. Good luck to you, sir. Raymond Golding.
He's He's here.
Mr. Golding, you were charged with possession of cannabis, less than 20 grams, a bike violation, and 3 counts of violation of probation. Looks like on separate cases. On count 1, your bond is $100. On count 2, it's an infraction, so it's a 0 bond. And counts 3, 4, and 5, you are being held no bond. You have a status conference set on your violations of probation on 11/21, which I believe is a week from Tuesday, or it's next Tuesday rather, at 8:30 in the morning. Good luck to you, sir. Efrain Martinez.
He's here, President Judge Amin.
Mr. Martinez, good morning. You are charged with possession with intent to deliver alprazolam. I find probable cause on this, and your bond is $1,000.
How much did you say?
1,000.
Judge, and speaking, Mr. Martinez, he's requesting that you consider releasing him on pretrial. My understanding is he's been residing here his whole life. He's right now unemployed. He just got a job. I believe he has an interview this week with a construction company. He lives in Tamarack with his aunt. Judge, he graduated Piper High School, so he has strong ties to community. He doesn't know if his family's going to be financially be able to afford his bond, and that's why we'd be asking you to consider pretrial release.
I have his permanent address is Okeechobee, Florida.
That was my old address. No, I don't live in Okeechobee no more. That's what my father still lives there though.
Somewhat recent.
So, Judge, if the pretrial then can verify his address, would you consider pretrial?
I'm sorry? Oh, okay. State, what is his prior record?
One moment, Your Honor. Yeah. What, from when? The one from? Well, I'm checking to see if that's still open. I know he's got a warrant. I'm showing that he does. I heard you. My thing's spinning. I got it. Okay, Your Honor, he has an open domestic violence battery out of Lee County. Additionally, 2014 out of Lee County, sell delivery of cocaine, possession of cocaine. Yeah, I can tell you.
Respectfully, I'm going to deny the request for pretrial. It's a $1,000 bond.
Yes, sir.
Nixon Marisma.
Mr. Marisma declined to serve as a public defender, Judge.
Okay, Mr. Marisma, you were charged with possession with intent to deliver cannabis and a probation violation or community control violation. I do find probable cause on count 1, it's a $1,000 bond. Count 2, it's a no bond hold. Good luck to you, sir.
Eddie, you're next.
Eddie Payout.
Yes, sir.
How do you pronounce your last name? I'm sorry, I didn't hear that. Paiute, okay. Mr. Paiute, you were charged with 1 count of violation of probation on a felony charge. I find probable cause. You have a status conference set on 11/20, which is Monday, at 8:30 in the morning. You are currently being held no bond. Good luck to you, sir. Stephen Mizell.
Soft route, Your Honor.
Good morning, Your Honor.
Good morning, Mr. Mizell. You were charged with failing to register as a sex offender.
No, sir, that is not right, sir. I did register at the courthouse.
Failure to change
It's
or
the
renew your
license.
info.
The license I didn't change.
Right. All right. I do find probable cause. It's failure to change your residential within 48 hours. I am going to set your bond at $5,000. Good luck to you, sir. Marlon Chamorro. Yeah, the name is familiar to me. Okay. this the last I have?
We have perfection.
Oh, okay.
This was the
Right.
Scrivener's error.
Says you.
No, it turned out to be. Just a second. The FTD, FTP.
Field tested positive on suit. Okay. All right.
Just need Mr. Ike.
Darren Ike.
Mr. Ike is here, present judge in Maine. He declined to serve as public defender. He had private counsel, Mr. Nathan Nevins.
Okay. Mr. Ike, I guess it was yesterday, I think, that we magistrated your case, and I did not find probable cause because of the lack of a field test on the possession of cocaine. However, I've been provided with a amended complaint that indicates that the cocaine was field tested positive on the scene. So I do find probable cause on your case, and I'm setting your bond, or it is set at $1,000 on that. Good luck to you, sir. 1,000. All right. Thank you.
Now my favorite part of the day. No, I mean, it depends how you.
Ma'am.
Same rule.
Yes. I did.
Patrice, I got the info. Can I give it to you after the end of our third docket?
All right, we are on our third look docket. It's a new day. Okay.
New day.
So Cornelius Nelson?
I believe he's in, let me see.
North Broward.
Broward.
Okay, great.
Your Honor, just to advise you, Mr. Farberic, from what I can tell in Odyssey, I don't know, maybe Mr. Nelson can confirm this. It appears as though he is representing himself with the public defender as standby counsel. It looks like there was a, yeah, there was, and then from what I can see here, Mr. Nelson, there was a hearing before Judge Usan on the 27th, pro se motion for leave to proceed as self-counsel with appointment of standby counsel.
That's a violation.
Or was it Mr. Nelson? Did Judge Usan rule on that, or did he defer ruling on that?
He told me to wait to February the 2nd that he'll see if he'll grant me the motion to go proceed to go counsel. And I told him he's violating my pro se my rights as going due process of the Ferretta. Because he denied me to dismiss my attorney.
Okay. All right.
And then he tells me he's gonna leave the attorney to still be my standby counsel, and really he ain't supposed to be helping me. It's all on the face of the record, on transcript, where you'll see that he violated all due process and my civil rights as American citizen.
Your Honor, as you can see just by the dates, this is an older case. I can tell you the state has filed notice back in March of 2016 to declare Mr. Nelson a habitual offender. There's been, this case, there's been numerous motions filed in this case, motions for the 4th DCA that it appears were dismissed because Mr. Nelson was represented at the time.
All right,
Which in the DCA saying that due to the claims that I raised about the affidavit not being legally sworn in, and the officer committed perjury and forgery on the document.
All right, that's fine, sir. We're not here for that reason. We're here to review your bond, and at this time, I'm going to deny a motion for ROR. It's a crime of violence. I don't think it's really appropriate.
It wasn't never a battery on the officer. I just received the discovery motions, and all the discoveries on the discovery it says battery on the officer, no injuries.
Okay. All right. Well, that's a question for a trial, and I wish you the best of luck on that.
Okay.
Paul Leith.
I'll just show you right now.
Good luck, sir.
Because you could even do it if you're not doing it.
Oh, Lee.
You go to court calendar.
North Broward, Your Honor.
North Broward.
No, but here, you get the whole docket.
Morning, Mr. Leith.
FMA is in the morning, FMP is in the PM.
State, what's Mr. Leith's issue? He's got 2 bat Leos on this count, on this case.
One moment, Your Honor. I'm showing. He's being held on a total bond of $3,000.
Do you have any priors?
One moment. Yes.
All right. Well, given a prior history and the fact that these are battery on law enforcement officer cases, I'm going to deny a motion for ROR.
Judge, I don't know if the court would consider, I know the bond was 3,000. With regards to basically the drug charges, which is basically counts 2 through 5, I don't know if any of those bonds, there might be, I don't know if there are any bonds set on that, but I would ask the court if the court would consider at least RORing on those counts, maybe to lower the bond so that he could afford to get out.
Well, Your Honor, I can tell you 2 things I'd like to advise the court. The only charges that were filed were bat leo, possession of cocaine, tampering with evidence. He's got a $1,000 bond on all those. Specifically regarding his priors, he's been to prison for battery on a law enforcement officer. He was sentenced on 2 separate cases in 2005.
The motion's denied. Good luck to you, sir. Edward Walden.
Mr. Walden's here present, Judge at Maine. Mr. Walden, come on up.
Your Honor, as you can see, these involve 7, 8, and 9, these 2 cases.
Yeah.
Your Honor, I'm going to ask the court to deny the motion. On other cases, he's currently been sentenced to 15 years Florida State Prison out of Rockport for attempted murder, attempted robbery.
Okay, so it's a moot point. The motion for ROR is denied. It's not even in his best interest to be ROR in these cases.
Sure.
Yes.
Okay, thank you, Judge.
William Bellarose.
North Broward, Your Honor. Hello, Your Honor.
How you doing?
Your Honor, just aside from just the nature of the charge, Mr. Bellarose is in Rockport, and he's also, the state is seeking to classify him as a prison releasee reoffender. So just because, just since he's in Rockport and PRR, I think just based on that, he can be considered a danger to the community, and any further hearing should be set before his assigned judge.
Who's he in front of?
It is Judge Bober.
Okay. Yeah, I'm going to let Judge Bober decide any bond on this case. So as far as this hearing is concerned, I'm going to deny bond reduction.
Okay, so, sir, this wasn't a new charge, this is...
No, sir, it's just a review of your bond to see if there was a reason to lower or change your bond, and I'm not going to do anything with it at this time.
Oh, okay, so it's nothing new, it's just the same charge, they were trying to get the bond low.
Yes, sir.
Okay, thank you.
No problem.
So that's it?
Right. Jeremy Garrison.
Probably, he might be in North, I'm not sure.
Be advised, I was advised that Mr. Garrison was transported to court this morning, so I'm not sure if he's down there in holding.
Okay.
Your Honor, I can advise you, because I think we can take action. There's competency issues in this case. He actually, just a week ago, Judge Usan ordered that a 3rd doctor be appointed.
I'm also noting that it's a battery on an elderly person over 65. My parents would probably be very upset if I called them elderly, but they're way past that date. In any event, I'm going to deny it. I'm getting closer to that age. I'm denying it. Stephen Williams.
Stephen Williams. North Broward, Your Honor.
Good morning.
How you doing, Mr. Williams?
All right, sir.
Case. Okay, Your Honor, on Mr. Williams' case, his total bond is $3,000. He was charged with 2 counts of, I know it has 4 there, he was charged with 2 counts of burglary of a conveyance. Let's see. He was filed April 11th, arraigned April 24th. He's had calendar calls July 7th, October 6th, and I'm just checking his criminal history. His criminal history includes 2016 introduction of contraband into detention facility, 2016 grand theft auto, 364 days county jail, 2015 possession of methamphetamines, he received the same sentence concurrently, 2015 burglary of a conveyance and theft, 364 days, 2015 possession of PVP, 364 days. 2010, burglary of a conveyance, he violated probation, 364 days.
All right, I'm going to deny the motion.
Judge, I would just ask I understand the bond's 3,000. Clearly, you can't afford to bond out. It says his first arrest date was March 14th. Has he been in custody all that time?
He's been in custody that whole time. He's had 2 calendar calls and an arraignment with the public defender. I mean, I guess my question is, why hasn't a motion been filed before Judge Uson?
Judge, I would just ask the court. No, go ahead.
And just for the record, Judge, he's been back here before on a 30-day motion, and the bond was decreased at that time.
Yeah, at this point, I'm denying the motion for ROR. On Kerry Isaac, it's a robbery with no weapon.
He's out to court.
Yeah, it's not, robbery is not appropriate for this hearing anyway. And the same thing, so I'm denying that. Ms. Ryan Santiago is also a robbery with no weapon. I'm going to deny an ROR on that.
Santiago is here, Your Honor.
Good morning, Mr. Santiago. Mr. Santiago, I don't feel that the charge of robbery is appropriate for this third look docket, so I'm denying the motion to lower the bond at this time, but that doesn't mean that your division judge couldn't review your bond and do something with it, but just as far as today is concerned, I'm not going to lower your bond. So good luck to you, sir. Kelso Leva?
Judge, that's a medical reset.
Is he a convicted oh, it's firearm a convicted felon. I'm denying that.
Dangerous firearm.
Yes. Roy Addison?
Conti.
What's Mr. Addison's issue?
The main issue is, Your Honor, one moment. I'm showing that he has three separate felonies, two separate open felonies, 2 separate grand theft autos, and a third case with 2 counts of uttering a forged instrument and grand theft. 2014, he was convicted of grand theft of a firearm, false imprisonment, tampering with a witness or victim, and battery. He was sentenced to 34 months. 2013, strong arm robbery, 34 months state prison.
All right. I'm denying Mr. Addison.
Would the court consider some kind of bond reduction? Clearly, he is unable to bond out. I know he has 2 cases that are on the docket. He has another one right behind it.
He's got more than 2 cases, so there's unfortunately, he's got multiple cases going at this time. I just don't think that it's.
And on one of them, we've actually filed a motion that is going to be scheduled to revoke his bond before Judge Uson.
I am. Schneider Valsen.
Mr. Valsen's here on main, Judge?
It's burglary conveyance.
Yeah, one moment, Your Honor.
Judge, I don't know, I know the docket says burglary, but I don't know if maybe in the information it actually reflects an attempted burglary?
I believe it is an attempted burglary. He was given
a $5,000 bond, I believe, plus pretrial with some sort of conditions. Judge, he can't afford the $5,000 bond. He does live with his sister in Fort Lauderdale, been residing at the same location for 6 years. Judge, he has a job waiting for him. It's going to be at a shop called Johnson Welding, which is located in Sunrise. We'd be asking you to consider releasing Mr. Valsen on pretrial release.
Your Honor, he's okay, 2016, failing to register as career offender. 2013, battery on a law enforcement officer. He was sentenced to 37 months in Florida State Prison as a habitual offender. Your Honor, does pretrial know, was the pretrial with GPS? Was it, Your Honor, at a minimum, and if I could just have a moment, I just want to read see the allegations also. Your Honor, if the court is inclined to modify the bond, we would just, the state would just ask at a minimum to keep the pretrial release GPS monitor component in place.
Judge, would you consider level 2 so that he can work and then he wouldn't be confined to his home?
Sir, you're a welder?
Yes, sir.
What kind of material do you weld?
Doors, windows.
What type of welder do you use? Yeah. MIG, TIG.
TIG.
That is the judge knows about welding.
Okay. What kind of how long have you been welding?
5 years.
Okay. Do you use any gas when you're welding?
Yes, sir.
What kind of gas do you use?
I would imagine someone that's been doing this for 5 years would know that. Now, Your Honor, I'm taking that back. I would object to a bond modification because now I have reason to believe that he's information he's providing Mr. Romero is misleading the court.
Judge, I would just, I don't know because I haven't spoken to him, but it's very possible he could work for somebody who sets that up. He just goes in and welds.
Not likely. Having a little bit of experience in the field myself.
What could happen is basically he could provide the, I guess, the contact information of his employer to pretrial with the schedule. He's going to be on GPS. They're going to see if he actually shows up to Mr. Johnson welding at sunrise, and if he's not there,
It's not. My concern is it's if in fact, and it does appear he doesn't. I mean, from my impression is he should know the answer to that question, and if he can't, then I question whether he's in fact involved in welding, and if that's the information that's being passed along, then I have a concern that it's not being truthful.
This is the only thing he has pending right now. He's been in since
July 6th, I believe.
Actually, well, if I could just, Your Honor, I just want to.
I will. I'll do this. I will do that. You know what? I'll give him a shot. You know, they're going to have to verify that he has a job. If he doesn't have a job, then I'm going to leave everything in place. But,
typically what happens is when he's placed on a GPS level 2, they tell us that they're going to work. We don't just shut them out until we actually get them.
okay, that's fine.
Say he's welding at Johnson's all day long, and if we don't have something, and not from, on a piece of toilet paper, it has to be something real that he's verified.
Okay.
He's gonna say.
So I will do that. I will ROR him to pretrial with a level 2 GPS monitor, and he's going to have to verify his work. Although right now it seems kind of sketchy.
Please explain to him if he's not verified, he loses his bond.
Right. I mean, and if that's not if they can't verify his work, then he's going to lose that bond.
Right, like, in essence, Your Honor, I understand he's been in custody since July. And since July, he's been bondable. Right now, if the court takes that off, takes the bond off, and just leaves him as GPS only, he will be in essence held without a bond. If we cannot verify him, he will continue to be held without a bond until he returns to his division judge.
Do you understand that, sir?
Judge, what I would ask.
Yes, sir.
Okay.
Pre-trial, try to verify it and have to reset for a couple days because.
No, I mean, yeah. No, I'm gonna delete the monetary, obligation on the bond of the $5,000 and let him, go to a level 2 GPS, pending verification.
No, Your Honor, we're not putting back pending. It
Okay,
says
level
GPS.
2 GPS.
Thank you, Your Honor.
You're welcome. All right, sir, good
And
luck to
you'll
you.
waive the cost of the monitor, Judge? I think it's.
No, not if he's working. Not if he's working, he doesn't need to waive the cost of the monitor.
Okay.
Okay. Thomas Jackson?
Just to advise the court, this was, I don't believe this is a burglary of a dwelling. It was filed as a burglary of a structure.
Okay.
Bond motion was filed September 5th. I don't see anything in Odyssey that it was ever heard by Judge Usan. He was arraigned on September 5th. I'd have to check. I imagine pretrial doesn't have any notes on him, right? As far as criminal history?
Checking some stuff out, Mr. Jackson.
You okay?
Ladies,
Yeah, but she's not gonna understand you say that.
yeah, but I want to see this lady. I know.
You never say that to me. Just be one more moment. Okay. I'm not showing any criminal history, Judge. I think his total bond is $2,600.
Mr. Jackson?
Yes, sir.
They're telling me you don't have any prior history, or at least they don't see any prior history, and your bond is $2,600.
Yes.
And you're saying this is a burglary structure, not a burglary dwelling?
It's a burglary structure.
Okay. What kind of structure was it?
It was, or is,
Oh, a school? Okay. All right. All right. If, do you have a place to stay? Where do you live?
I have a home. It's in North Lauderdale.
Okay. Does that home have an address?
Yes, sir.
What is-
Southwest 9th Street,
What's the address of your house?
7716,
Southwest?
9th Street.
Is that a house or apartment?
Is that a house or an apartment?
It's a house.
33068?
3306.
Yes.
All right, and who lives there?
My grandparents and my mom and my dad.
Okay, and how long have you lived there?
Since the day I was born.
Okay. All right.
Can we get a phone number?
Yeah, is there a phone number there?
I don't have a house phone number, but my mom has a phone number.
Okay, what's that?
954-554-1125.
Is that 554-1125?
That is.
What is her name?
Pardon?
What is her name? What's her name?
Laura
Oh.
Olson.
Laura Jackson?
Did you say Laura?
Laura Olson.
Olson.
But that's, they didn't get a chance to change it
Okay.
to Jackson.
All right, State, you're saying that you have no priors?
I ran them through the Florida clerk system, the local, NCIC, I'm not showing anything, FCIC.
Well, he's just 18, so.
I ran it through DJJ also, and I didn't get a hit.
Okay. All right, I mean, under the circumstances, I think that that's why we have this docket, and I would, I'll ROR him to pretrial.
Judge, would the court consider just a straight ROR? And the reason I'm asking for that, you have somebody who has no criminal record, he's lived in the same address all of his life. He has been in custody now almost 4 months. And even if this case is to resolve itself, chances are he would probably get some kind of probation or that. So I would just ask that the court would consider just a straight ROR.
Your Honor, I think at this point, you know, we're not at a second look where it's, you know, the case is 10 days old. He's had an arraignment, he's been before his judge. I think some supervision would be appropriate.
Yeah, I'd feel more comfortable having some supervision, and it's not really, straight pretrial is not that onerous that he couldn't do it. It's certainly better than being in custody, so I will ROR him to straight pretrial.
Standard pretrial.
Standard
supervision?
pretrial, yes.
Thank you, Judge.
Thanks. All right, good luck to you, sir. You're gonna have to report to pretrial when you get out, okay?
Okay.
All right then.
Thank you, sir.
All right, take care. Jeffrey Manley?
No.
Mr. Manley's here present, Judge Maine?
Okay.
I know it says burglary, this is like the opposite of the last case. It says burglary structure, it was upfiled to a burglary of a dwelling. Mr. Manley has a lengthy criminal history. 2014, he was sentenced to 25 months state prison, depriving an officer of a weapon or communications device, possession of PVP. In 08, resisting with violence and possession of cocaine, he got 5 years HO, PRR. 09, another 5 years on a possession of cocaine, aggravated fleeing and eluding, 5 years. He's had prior burglaries that he went to prison on, delivery of cocaine.
All right.
Judge, Mr. Manley advised me that he lives with his mother in Fort Lauderdale. He's been residing there for 30 years. He was on disability. He wasn't employed. He was on disability, but when he came in custody, he's been in custody now, I believe, for about almost 3 months. His disability benefits have cut off, so right now financially he has no sort of income. He's in on a $5,000 bond. He can't afford to put a bond. He's asking, Your Honor, if you would consider releasing him to pretrial, even level 1, the house arrest.
Yeah, unfortunately, with Mr. Manley's history and the fact that this is an upfile to a burglary of a dwelling, I'm not inclined to change his bond at all. Good luck to you, sir.
Yes,
Be
Judge.
denied. Cicely Mack?
North Broward, Your Honor, she's approaching.
Your Honor, not only based on count one, I can just tell you from having Ms. Mack come through here on trespasses and batteries, and I just don't believe that she is, in any way, is she a good candidate for pretrial. I don't believe I don't have any confidence that she'd be able to, even standard pretrial, satisfy the requirements.
It's also involves a battery, so respectfully, I don't think this is a properly in front of a third look docket, so I'm denying the motion. Good luck to you, ma'am.
Huh?
I'm not changing your bond at all right now, okay?
Well, I go in front of the judge on Friday to
Okay.
get a program.
Okay, good, perfect.
So I don't know why y'all waste my time this morning. That's what I'm trying
Well,
to figure out.
we won't waste any more of your time. Good luck to you, ma'am.
I hope not.
Have a nice day.
Oh, he said, go tell me this shit right here. Oh.
Good luck with that program. Is it an anger management program? Derek Smith?
Coffee.
Your Honor, Mr. Smith, the charges were filed as presented on the booking. He's actually, it was filed October 30th. Your Honor, we're going to be asking, he hasn't been scheduled for an arraignment yet before Judge Siegel, but we're asking that any matters of bond be taken up before Judge Siegel based on these charges of criminal history. 2011, burglary of a conveyance and felony theft, 26.5 months state prison. 2011, felony theft resisting immersion, 26.5 months. 2011, burglary of an occupied dwelling, 16.5 months state prison. Theft 2010, grand theft 08, theft 08, theft 09.
All right, Mr. Smith, it looks like your charges have been filed, and I think that any bond motions are best set in front of the division judge. So I'm not going to do anything with your bond right now, one way or another, but I wish you the best of luck.
Thank you.
Rachel Fernando?
North Broward, Your Honor.
Thank you.
Your Honor, a charge has not been filed yet in this case. However, based on the nature of the charge, we'd be asking the court to take no action, and that as far as an ROR, that if a motion is filed, then obviously it can be addressed at that time for the state not filing an information. I don't believe we're at 33.
We're right there at 30.
Judge,
We're
it's
just
actually,
over 30, but I don't think we're at 33.
if the arrest date is correct on here, which would be October 13th, the 30th day would have been the 12th, so today would be the 33rd day. She would be entitled to be ROR'd unless the,
One moment, Your Honor. Your Honor, if we could just put this on a brief recall.
Yeah, okay, man, we're gonna put this on a brief recall. We're just checking a few things out, okay? All right,
Okay.
In the meantime, let me call Nicholas Spence.
It's okay, I think there's another issue, but it's, I don't know why they do this.
Morning, Mr. Spence.
Hi, good morning.
All right. What's up with Mr. Spence's?
Yeah, I don't know if this is a second or a third look, frankly. His bond's $4,200. It's been 2.5 weeks since his arrest. Oh. There you go.
All right, Mr. Spence, for right now, it doesn't look like there's any place that I could release you to on pretrial, and, go ahead.
I do have an address. I have two.
Whose address
I have
is it?
I have two options, and if possible, I really do really want to release on pretrial so I can keep my job to take care of my mom and my daughter. But my main address is 4320 Northwest 5th Ter Plantation, Florida 33317. And
Is that your sister's address?
Yes.
Okay, but your sister apparently does not want you there on pretrial, so.
Oh, well then, I have another address. I don't completely know the address, but I have the number that I called my brother. It's because my sister, it's her landlord situation, so I understand that.
Right.
But I have another number. If possible, the court will be able to try.
Yeah, but what they're telling me here, sir, is that you live in Georgia.
No, I don't live in Georgia. It was everything was just a big misunderstanding how everything happened in the past few years, but finally came to understand. This is where I stay. This is the only place I'm able to really get an address. This is where I work at. This is where I work to provide for my mother and my daughter. It's been like that since 2012, but the Georgia incident was a big accident that I really, really learned from. It's a big, big accident.
Well, you've been in custody for about 3 weeks now. State, you haven't made a filing decision on this, right? No. All right. I'm not going to take action one way or another on your case right now. We're going to wait and see what the state files on it, and that'd probably be happening sometime in the near future. So you may be back up on this docket at that time, but at this time, I'm not going to take any action on it.
Okay.
Good luck to you, sir.
Thank you.
Any indication, anything on Rachel Fernando?
I'm finding it right now.
Oh, okay.
Yes.
All right.
Thank you, Your Honor.
Thank you. While we're waiting on Ms. Fernando, let me take DeCorian Delhomme. Wasn't he just in? I'm taking no action on Spence. Okay, anybody in the main jail on Delhomme? No?
On who, Judge?
DeCorian Delhomme?
I don't know. I don't have paperwork on that person.
Well, I can tell you, his bonds, I mean, if we're saying, I can tell you right now, if we're saying
But he's
that
not there.
5,000.
Hector, are the deputies still there?
If 5,000 is the cutoff, his.
Patrice is saying she called over there to tell him earlier.
Oh. I don't know. They're calling about a person that I don't have no idea who they're referring to. What's the name of the person?
DeCorian Delhomme, or Delhomme.
DeCorian, I'm being informed, was in regular court.
But Judge, I can advise you, if 5,000 is now the cutoff, his bond's above 5,000. His total bond's $6,600.
Okay.
Dale? Hey.
I'll just delete it. He's in regular court anyway.
She's up for.
Lakita Long? No, I'm deleting. Lakita Long?
Yes, Your Honor.
Okay.
Since I'm being told, if we do file it, you just file it as an assault.
Morning, Ms. Long.
Good morning.
What's the deal with Ms. Long?
Thanks, man. Bye-bye. Who is this? You want me to answer that question? This is Lakita Long?
Yeah.
Okay. Is that still going on over there?
You guys are upset this night.
I'm very, very sorry to have upset her.
In addition to this case, she had an open possession of cocaine, municipal ordinance prostitution, and her bond, she was out on bond, her bondsman surrendered her bonds.
Oh.
So even her bondsman didn't consider her.
All right.
Wait, can I just ask when the arrest was on the other one?
This arrest was October 30th.
And she was bond surrendered, she bonded out on October 30th? And then
No, she was arrested for the case before the court. She was arrested October 30th. Okay, she was arrested October 20, sorry. Okay, she was arrested August 22nd for possession of cocaine, and municipal city ordinance for prostitution. She bonded out and was released August 26th for $1,300. She was then arrested October 30th on these charges, and since at some point between October 30th and now, the bondsman that bonded her out on the cocaine.
She would have most likely have been, bond would have been revoked on that.
Well, I don't know. It might have. The judge that was here on first appearance might have declined to take. Might have declined to consider it.
All right, well,
the point is,
in any event, obviously, being out on bond is not, or even on ROR is really not an option in my estimation. Ma'am, unfortunately, I don't think that I'm going to take any. I'm going to deny the motion for ROR in your case. It looks like you have another pending case, and if it had been in front of me at bond court, I probably would have revoked your other bond. That didn't happen, but you've got a bond on this case, and good luck to you.
Your Honor?
Yes, ma'am.
May I say something?
You may, but it's probably not in your best interest, but go ahead.
I was just gonna say, the bondsman was a personal friend, and my mom asked for me to be in here because I had relapsed.
Okay.
I'm trying to get out to get my life together.
I understand that, ma'am, and that may be possible, but it's just not going to be today, okay? Good luck to you, ma'am.
and Your Honor, we can go back to Ms. Fernando's case.
Yes.
Because we're going to be able to take care of this. I just have some important information. For
Okay. All right.
Mike, you're familiar with
Is
that?
she in North Broward, Rachel
mental
Fernando?
health diversion program.
Yes, sir.
Okay, then good. Okay, Your Honor, here's what's going on. I don't know if you're familiar with this. I'm not that familiar. There's a mental health diversion program where the state actually holds off on filing an information, and assuming the defendant completes a program, we file a no info.
Okay.
I spoke with Dale Geisler, who's the case filer in this case, and even if we were to file a charge at some point, he would only be filing a misdemeanor assault on a law enforcement officer. So taking all that in consideration, I have no objection to an ROR.
Okay, straight ROR?
Yeah, what you'll have to do, and I imagine, Mike, if you want to check, I believe she's probably already been given information by her public defender that she's going to have to meet with a doctor once she gets out, and they have to have an evaluation, and it's all part of the program.
All right, and her prior history, no prior history?
I didn't see anything out of Broward.
Okay. All right, Ms. Fernando, I'm listening to the state attorney. What's the bond currently on?
Check. Oh, that's not it. Her bond was set at $2,500.
Okay, Ms. Fernando, I'm talking to the state here, and they've indicated to me that you would probably be eligible to go into a diversionary program, and it would require you meeting with some doctors and whatnot, but in any event, given the state's representations that I have, I'm going to release you on your own recognizance. That being said, you need to keep in touch. You're currently, you have a public defender appointed to your case, so you need to keep in touch with them so they can give you further instructions so that you don't end up back here. Do you understand what I'm saying?
Yes.
Okay. Have you met with your public defender?
Yes.
Okay. All right, so I'm going to release you on your own recognizance, and please keep in contact with your public defender, okay?
Okay.
All right, good luck to you, ma'am.
Thank you.
All right. That's all I have.